Dear students, today we can solve one more problem under administrative law. Here, the problem has been given. Here is a convict. He has written the letter to Supreme Court judge alleging torture by jail authorities, and we have to decide the authenticity or validity of this letter. So this aspect we have to do. That means here a convict already serving the jail sentence, he has written the letter from jail only, from the inside the jail only. He has sent the letter to the Supreme Court judge stating that the inmates, that is the convicts, they are suffering from the jail authorities. They have been exploited by the jail authorities. Whether this sort of the letter has got any value under the eyes of law. So this is the question. Here I have told you that you have to solve this problem according to the IRAC method, that is issue, rule, analysis, conclusion. So if you solve this problem under this method, you can easily get the answer. So here what we have to do, our first point is that we have to frame the issue. That means how far the letter sent by the convict who has already been sentenced, who is already spending time behind the bars, whether his letter can hold good the validity. That means to say, is a convict's letter to Supreme Court judge alleging torture is valid or authentic. So in this way, you have to frame the issue. Then you will get all the answer for that one. Otherwise, if you simply go on writing the what you call essay type of answers, you don't get the what you call legal answers. So that is the thing. That is my what you call sincere effort to make you understand how to solve the problem. Then we have to see what is the provision of law. That means here provision of law, rule of law will be automatically, which will come under the fundamental rights. Courts can consider complaints from the prisoners and they ensure fundamental rights are protected. Or you can write what you call the courts can protect the fundamental rights of the convicts. That means how the courts can ensure that the convicts' rights with regard to the alleged torture can be what you call the convicts can be protected, means by protecting their fundamental rights. That means here the letter itself can be termed as the what you call writ petition. So what sort of the writ petition? There are 5 kinds of writs are there: habeas corpus, mandamus, prohibition, certiorari and quo warranto. So if a person who is behind the bars, if we write a letter, and how far that can be converted into writ petition means the court has got the power. The court has got the judicial discretion. The court can enforce its judicial activism with regard to the converting that letter into writ petition. That may be, it may be what you call the habeas corpus petition. If it has been written by some other person, need not be advocate, a public spirited citizen, then it can be converted into what you call the public interest litigation. So here the main motto of the administrative law and the constitutional law to protect the rights and liberties of the citizens. So probably you have studied this aspect in the administrative law. That means administrative law has been evolved for protection of the rights and liberty of the people. Likewise, under fundamental rights also, certain rights are guaranteed to the citizens and also non-citizens also. Here, under the rule of law or provision of law is concerning that to file the writ petition. That means if it has been sent to the High Court, it will be considered as the writ petition under Article 226 and 227. If it has been sent to the Supreme Court, it can be converted into Article 32. So this is the thing we can see. And all the things we have to discuss with regard to the issue and the rule of law under this analysis. Here we have to discuss the what is the law principles, relevant legal principles we have to discuss, and we have to discuss the relevant case laws, then we have to sum up with regard to the issue point of view. Then we have to discuss the issue. Here, probably you understand what is the issue. Here, now we can go to the what is the relevant legal principles. Here, what has been said, Article 32 of the Constitution of India provides for constitutional remedies, including the right to approach the Supreme Court for the enforcement of the fundamental rights. So here, what has been said with regard to the concept of habeas corpus is that it is a what you call a process for securing the liberty of the subject by affording an effective means of immediate relief from unlawful or unjustifiable detention, whether in the prison or private custody. This aspect has been already been discussed in the case of ADM Jabalpur versus Shivkant Shukla. Here, Justice Khanna has said that even the person is in the what you call prison or private custody, if such detention is unlawful or unjustifiable, then this sort of the writ of habeas corpus can be filed. Here, what we can see, so this principles we can evolve. That means if it has been, this letter has been sent with regard to the human right violation, then it can be treated as the what we call the writ petition. If it has been filed by the persons who are not concerning with regard to the such aspect, the persons probably we can think that they have got the locus standi. Normally what we can think, the person who doesn't have the what you call interest in the subject matter, we can say that he doesn't have the locus standi. But with regard to the public interest litigation, even though the person doesn't have the interest in the subject matter or in the petition, is nowhere concerned with regard to petition, he can file the public interest litigation. So this aspect we can see under two case laws, in Husainara Khatun was the state of Bihar, as well as in the what you call Sheila Barse, a state of Maharashtra. In two these cases, a journalist has filed the public interest litigation. Here, under Husainara Khatun was the state of Bihar, the journalist has sent the letter to the court, that is Supreme Court, with regard to the plight of the under trial prisoners. That means the plight means there is human right violations are there inside the jail. So this is the thing we can see under Husainara Khatun versus state of Bihar. Likewise, in Sheila Barse was the state of Maharashtra, the custodial violence against the women prisoners. Here also journalist has sent the letter. So that letter itself is termed as the PAL. And with regard to the what is the issue here? With regard to the concerning to the issue means what is the real the legal aspect we have to consider is whether the letter sent by the convict can be treated as the valid one or authentic one, whether it has got the any valid point under the eyes of law means definitely yes. This can be, we can see under what you call in the case law of Sunil Batra versus Delhi administration. Here a convict has sent the letter to the Supreme Court judge, and that letter itself is converted into writ of habeas corpus under Article 32 with regard to the torture given by the jail authorities. So this aspect has been highlighted under the Sunil Batra versus Delhi administration. Likewise, in one more case law, that is People's Union for Democratic Rights and Union of India, it has been highlighted that what is the locus standi to file the petition like this. Whether such petitions has got any value under eyes of law means definitely yes. That can be said as public interest litigation. So ultimately what we have to sum up that the letter sent by the detainee, the person who is spending the sentence behind the bars, he can his letter sent to the Supreme Court judge, it is valid one. That means it can be converted into writ petition, that is writ of habeas corpus, and the court can act on that writ petition. So he can succeed in this petition. So this is the thing what we have to say what we have to write with regard to the judicial activism and also the legal principles under the administrative law. Okay, in future classes, I can take up number of administrative law problems because most of the students they could not able to solve these problems, so they used to get less marks in this what you call problem solving questions. So that's why it's my sincere attempt to solve the problems as far as possible with regard to the all the subjects of law.